Okay, well, good evening, everyone, and thank you for joining. I'm Michael Ettinger from Ettinger Law Firm, and this is our webinar, 4 Advantages of Using Trusts. Here's the wonderful staff of Ettinger Law Firm, and you can see beside me is my lovely wife and law partner, Suzanne Ettinger, all of our other staff, and our 35th anniversary wreath, or laurel, I guess you'd call it. We started in 1991, founded Ettinger Law Firm after I was already an attorney for 11 years. I was admitted to the New York State Bar in 1980. I was a litigation attorney till 1991 when I stopped litigating and founded Ettinger Law Firm, devoted exclusively to elder law estate planning. Our practice consists of trusts and estates, wills and probate, estate tax saving strategies, Medicaid applications, Medicaid trusts. We have 5 offices on Long Island, 2 in Nassau, 3 in Suffolk. I happen to be here today in the home office in Huntington, which is also the town where Suzanne and I reside. And we have offices in Staten Island, Westchester, the Hudson Valley, Rockland County. Orange is in the Hudson Valley, Orange County. We're in Middletown. In Dutchess County, we're in Rhinebeck and Fishkill, and we are in Albany. We are going to now proceed to move to the screen share. Well, we're actually on the screen share. We're going to start the seminar, and I want to maybe, before I even start, I may want to empathize a little bit with people out there looking to get information on elder law estate planning. One of the things I'm fond of saying is when it comes to elder law estate planning, there's more misinformation than information. So I believe tonight you'll obtain fully correct information. In fact, I'm certain of it. I've written 3 books on the subject. The first one was back in 2010, but my new book in 2025 edition, Ettinger Law Firm's Guide to Protecting Your Future. We'll be talking about that, and it's about 300 pages written in plain English, short chapters, large print, easy to read, and everything you ever needed to know about estate planning is in that book. And you can actually download it for free off my website. You'll get the ebook version, or you can order it on Amazon.com for a very modest fee. Or for anyone who comes into the office, we give you a free copy of my book, and we tell you which chapters apply to you. So let's get started. The first question is, what is elder law estate planning? Well, it's an area of law that combines the features of elder law, which is disability planning. Who's going to handle your affairs if you become disabled? Who's going to make medical, financial, and legal decisions for you? How are you going to protect your assets from the cost of long-term care, become eligible for Medicaid for home care or facility care? Estate planning is really death planning. Who gets your assets after you're gone? And estate planning has been defined as getting your assets to whom you want, when you want, the way you want, with the least amount of taxes and legal fees possible. Everybody needs an estate plan. The last time I checked, the mortality rate was stuck at 100%. So estate planning is death planning, elder law is disability planning. Here at Ettinger Law Firm, I like to say we use trusts to create order out of chaos. So trusts avoid the pitfalls of wills by saving considerable time and money in settling the estate. Not everybody understands that a will has to go to probate. Probate means to prove the will. It's out of a Latin word, and it means to prove the will. All wills have to be proved to be a valid will. And that means you have to go to court and prove to the judge at the time of signing the will that person was of sound mind, memory and understanding, was able to read and write and converse the English language, was able to understand the objects of their bounty, wasn't under any fraud or undue influence. This can take months or years, depending on the complexity, the availability of witnesses, and a host of other factors, not the least of which is the judge's temperament and personality. Um, we use trust to avoid court proceedings on death, save considerable time. We can settle trust in months now instead of years, and at a fraction of the cost of going to court. We use trust to avoid guardianship. If you become disabled, we're going to talk about that. Guardianship is if you become disabled, you don't have a plan. New York State has a plan for you. It's not a happy situation. We're going to talk about keeping assets in the bloodline for your grandchildren or whoever you choose instead of going to in-laws and their families. And we're going to finally talk about protecting your home and life savings from long-term care costs. I'm aware I have pages and pages of questions. I'm going to answer as many of them as I can in the question and answer session. So let's continue. Next slide. So the first of the four advantages of trust is trust protect you from guardianship proceedings if you become disabled. Wills don't do that because will takes effect at death. So clearly there's no plan for disability. This is why elder law has risen to the forefront, because the will had no plan for what happens if you're sick, homebound, or disabled. And eventually, with advances in medical science and everybody living so much longer, about half of us will have a period where we're unable to handle our affairs. So we need a plan for that. A trust, because it takes effect while you're living, which is why it's called a living trust, takes care of all three phases of your life. You can run it yourself now while you're healthy and competent. You have a plan for the people you choose to take over if you become sick or disabled. And it says who gets the assets after you're gone, but without the expense and delay of the probate court proceeding. So let's talk about these guardianship proceedings, which we want to avoid. We mentioned chance of becoming disabled, about half of all people. Now, without a plan, New York State has written a plan for you. It's called guardianship proceedings. Anyone, we'll hold off on this for a moment. But how does a guardianship start? Well, somebody, it could be a friend, a relative, a professional, doctor, dentist, accountant, lawyer, makes a report to Adult Protective Services that you're acting funny or somebody's taking advantage of you or you're not able to handle your affairs, and they commence a guardianship proceeding to have someone handle your affairs. Now you may say, well, this is not a problem. I already gave a power of attorney to so-and-so. Well, unknown to most people, the courts in New York have the power to cancel your power of attorney and appoint someone else as guardian. So the judge is going to scrutinize and determine if that's the person the court feels is the best person to handle your affairs, or maybe somebody else. One of the reasons a court might override your power of attorney is they might say, well, that person you picked as a power of attorney is also one of your heirs. So they have a conflict. If they spend it on you, it's coming out of their inheritance. So a power of attorney, while it's a very important document to have, and we give every client power of attorney, doesn't necessarily stop a guardianship proceeding. So the court chooses who the legal guardian will be, and it may be a complete stranger. In fact, it often is. Sometimes the judge picks somebody who helped the judge get elected. We have no control over who the legal guardian would be. So elder law estate planning is really, as you'll see, about taking back control from the courts and government, giving it back to you and your family. We're going to see how that happens. So how do you overcome a guardianship proceeding? It's almost impossible. You have to get a court order reversing it, and these are extremely rare things to happen. Not only that, but this unfortunate proceeding is something that you pay for, and it can be expensive, time-consuming, and very stressful. Multiple court hearings, testimony from witnesses, not knowing who's going to be appointed and when it's going to conclude is very stressful on everybody involved, and there may be sibling rivalry all kinds of unpleasant things happen there. Another thing, when your family is in charge and you need Medicaid, they go to see your elder law attorney. Hopefully, it's us here at Ettinger Law Firm, but they go see your elder law attorney, and the elder law attorney proceeds to do what's in your family's best interest. When a legal guardian is appointed, it's quite different because to protect your assets, we very often have to move them to other people in your family. Under Medicaid, it's move it or lose it. But if you have a legal guardian can't take your money and give it to your children for safekeeping because they're your legal guardian. They can only use the money for you. So they have very limited options. They have to go to court and ask a judge for permission to move assets to protect them from the cost of long-term care. Well, sometimes the judge will grant it, sometimes the judge won't. It's up to the judge. I lost a case like that a number of years ago where the judge said, well, in my opinion, the asset should be used for mom's care. And the judge didn't think that there was any good reason to protect the assets for the heirs. Now, we know very likely mom would have liked her heirs to get something, but the judge didn't look at it that way, and the judge was in charge, which is why you want to take back control, have your family in charge. As I say, conflicts can arise between what the family wants and what the guardian wants. Remember, it's not the guardian's money. They're not concerned with preserving it for the family, and they have interests that are different from yours. So what's the takeaway from this? To avoid guardianship proceedings at all costs. That's what most elder law attorneys would say. Hopefully they would all say that. Um, so how does a revocable trust avoid guardianship? Well, unlike a will, the trust takes effect while you're living. Again, that's why they call it a living trust, and it stays in effect when you're disabled. So in the trust, if it's a revocable trust now, you appoint yourself as the trustee, the manager of the trust. So you retitle the assets from your name to the name of the trust. So let's say your name is Mary Jones. So we're going to deed your house from Mary Jones to Mary Jones trustee, the Mary Jones Living Trust, dated whatever the date of the trust is. We'll show you how to change and name your investments, your bank accounts, not IRAs. They don't go into the trust. IRAs have a designated beneficiary. They don't go through probate. And, you'll learn later on that IRAs are also exempt from Medicaid. The principal is exempt. If you need long-term care, they get your required minimum distribution, the RMD, that's income, they get the income, but they can't go into the IRA. The IRA itself is protected. So you get your assets into the trust, and you name your backup trustee, one or more of your adult children. I know people who are listening don't have children. They can pick a friend, a relative. They can even pick the lawyers here at Ettinger Law Firm. But if you set up a trust and you name a backup trustee, this defeats a guardianship because here the person you know and trust is in control instead of the legal guardian. You can take back control when you recover, but a judge in New York cannot override your trust. The judge, if you recall, I said a few moments ago, can cancel your power of attorney, put somebody else in charge. Court can cancel the trust. That's why we like trusts, because trusts guarantee you're going to get the people you want in the event of disability. If you think about it, planning for disability is more important than planning for death, because planning for disability is for you. Well, you're number one. Planning for death is for someone else. So you come first, and then they get it after you're gone. So sometimes we say planning for disability is more important than planning for death, and that makes a will completely obsolete because a will is only planning for death and no plan for disability. The other thing we want to mention is the elder law power of attorney. Not all powers of attorney are created equal, okay? The standard form power of attorney, we call that over-the-counter medicine. The elder law power of attorney is prescription strength. And it's just like medicine. What happens if you only have over-the-counter medicine and you need prescription strength? Well, you know what happens. It doesn't work. It's not strong enough. So we like this prescription strength elder law power of attorney. Has maybe 50 powers that are not in the standard form, but they're the very important powers you need if you become disabled. We use these powers to transfer and protect assets in the event you become disabled. And the most important of those is something called the unlimited gifting power. So the standard form power of attorney allows your agents to gift up to $5,000 a year. Well, that's not going to serve you very well if you're going into nursing home and you have 300,000 and can only move 5,000 a year. Well, in 3 years you're going to have nothing, and the family will have kept 15,000. Under Medicaid law, if you have $300,000, there's an article on it on my website under Medicaid strategies. The website is trustlaw.com. It's also ettingerplan.com, both the same website. There's an article there that explains, let's say you're going into nursing home tomorrow. You did no planning. You have 300,000. I have a technique, not me alone, but every elder law attorney worth their salt knows the technique called half a loaf planning. You know what half a loaf is, better than none, right? Well, every elder law attorney worth their salt knows how to transfer half of that 300,000 or 150,000 to the family and protect that as long as they spend the other 150,000 on your care. So we can actually save half the assets on the nursing home doorstep, but we have to be able to move them. So every elder law attorney uses something called the unlimited gifting power and a power of attorney. So your family could move any amount of money. So you have the elder law power of attorney. You have to go into a nursing home tomorrow. We use that to transfer 150,000 to the kids, use the other 150,000 to pay for you, and they get to keep half the money. But you have to have the power to move it because, again, it's move it or lose it. So you want the elder law power of attorney. The standard form power of attorney won't do you hardly any good in the event you become disabled. It's unfortunate, but a lot of people have a false sense of security because they didn't see an elder law firm to get this prescription strength form. So reason number one or the first advantage of trust, it avoids guardianship proceeding if you become disabled, guarantees you're going to get the person you choose. I can't, there's a reason that's number one, because it's the most important one, because it's all about you and taking care of you and having your people in charge and feeling secure that nobody will be able to interfere or interrupt what you chose. Reason number two is the popular one, that is, trust protect you from probate court proceedings on death, wills don't. I already mentioned wills have to go to court to settle. That's the infamous probate court proceeding. They can be really head scratching. I mean, I had a probate proceeding where a judge required me to prove that somebody who would have been 125 years old was not alive. Even though the longest living person in history is only 122, I had to make proof to the court that somebody was not living who would have been 125. So, and then also, if you can't find an heir or relative, you have to hire a genealogist, you have to publish in newspapers. All kinds of, you have an estranged family member. A lot of things go wrong in probate court proceedings. In fact, it's because of probate court proceedings that I became a trust and estates lawyer. If you were here from the beginning, I mentioned that I was a estate litigation attorney for 11 years before I started the practice elder law firm, Ettinger, in 1991. And the reason I started it was because I was actually in my car. I was chasing an ambulance, so to speak, which means I was on a personal injury call, going to see somebody, and I heard on the radio for the first time back in 1990, if you set up a trust, you don't have to go to court to settle. I thought, wow, who doesn't want that? I thought it was too good to be true. And I looked into it, and I found out not only was it true, but it was something that was virtually unknown at that time. So I started to do seminars in 1991. I did seminars from 1991 right up to 2019, the COVID, and I did in that time over 5,000 seminars teaching people about trust and avoiding probate court proceedings. I think it's terrific. I mean, here you can take back control and have your people in charge instead of the courts and the judges in charge. And I often said in my seminars, when you go to court, who's in charge? The judge. And I asked, does the judge always act in your best interest? Well, of course not. And then I would ask the audience, when the judge says jump, your answer has to be what? And people would say, how high? And I would say, no, how high, Your Honor? So we sometimes had fun with that. But as a lawyer, didn't like going to court because somebody else was in charge, and you can lose a case that you shouldn't lose, and you can win a case, of course, that you shouldn't win. It's a little bit like rolling the dice, and who wants to roll the dice with they and their family's assets? So trusts protect you from probate court proceedings on death. Wills don't. Wills have to go to court to be proved valid. Okay. And now the court takes control over the estate. How long does it take? Can't say. It's weeks, months, or years, depending on the court, how many cases they have, what the judge finds wrong with your case, additional proofs that the judge wants, additional evidence. Now, our executor named in the will cannot act until that will has been approved by the judge. So we're talking about possibly years of delay in getting assets to money and other assets. This is serious because you can't sell a house, you can't sell a co-op. You're paying taxes, you're paying common charges, you're paying carrying costs, utilities, etc. Things are going wrong. They're disintegrating. Everything starts to fall apart if somebody's not living in a house for any length of time. And then they may need the money to pay bills. The stock market could be going in the wrong direction. You can't get access to the assets. You can't do anything with the portfolio. Nothing good about this. So we're talking about something that you're paying a lot of money to get done. It takes a lot of time, and you're under constant stress. You don't know how much it'll cost or how long it'll take, or when you'll be able to get your hands on those assets. I mean, there's a reason trusts are so popular today. People have gotten the message that they don't want to get tied up in court. I mean, who would go to court if they didn't have to? I would assume nobody. Not only that, but the will is a public record. Anybody can go down and look at how much you had, who you left it to, where they live, what they're getting. It's from the wills have been around for hundreds of years, so it doesn't really comport with the privacy needs that people have today. Nobody wants all their information splashed all over the internet now. So let's look at the revocable trust. They avoid probate proceedings entirely for trust assets. It saves time. I mean, you know, it's unbelievable how much time it saves. I mean, if you have property out of state, you have to probate in New York and in the other state. It can take an incredible amount of time, legal fees and court costs. But you see, it says avoids probate proceedings entirely for trust assets. So the key to setting up a trust is getting the assets in the trust. Doesn't avoid probate if you don't get the assets in the trust. So we do that for you at Ettinger Law Firm. We can't do it all for you because we can't do the bank for you. You have to go into the bank. But we give you a turnkey package for the bank. Here, give this to the bank. This is everything they need. If you have a brokerage account, we'll contact your broker. We'll send them the documents and we'll give them instructions as to transfer you to your trust. If you have real estate, we do all the deeds for you. So we're very diligent in funding these trusts. And this is where 35 years of experience really comes in. It takes time to learn how to put assets into a trust, I mean, from the lawyer's point of view, and to cover all the different types of assets you have and deal with all the, ins and outs and details of funding a trust. So I think this is where experience really comes in. We don't just do the trust, we make sure the trust is fully funded so it's going to do what you expect it to do. And that is a matter of excellence. I don't know if you've ever hired a contractor to work on your house. It's the devil to get them to finish the job. They're very good up to 95%, the last 5%, very lucky if you can get them to do that. I just had my pool redone. It had a crack in it, and it was fairly expensive. And they have to redo the whole thing. But yeah, they were interim billed, and they sent me over a month ago the final bill. I said, as soon as they finish the work, I'll pay the final bill. It took them another month to finish. They wanted me to pay in full when it was 95% done. Again, um, going back to the trust, um, this is where a lot of law firms and lawyers fall down because it takes a lot of effort to get the last 5% done. We do it because it's the way we do things. We put in that extra effort, and that means it's going to work for you. Well, we care that it works. So now we're going to avoid court control of your estate, give you that control back to you and your family. Upon death, your backup trustee can act immediately without the need for a court of appointment. They have immediate access to the assets, to pay bills, to sell the house. Um, I had a client who died. He had a will. His son was the executor, and he had a property in Pennsylvania. So he went to Pennsylvania as executor. He listed the property for sale. And then he called me. He needed help with the closing. I said, you can't list it for sale and you get appointed. Until you get appointed, it's going to take you a couple of years because you have to probate in New York, then Pennsylvania. He said, well, what am I going to do for the couple of years? I guess I'll have to rent it. I said, we can't rent it because you're not appointed executor. You can't sign a lease. If his father had a trust, he could have sold it the week after, really a couple of weeks after his father died. All you need with the trust is the death certificate to show that the backup trustee is in charge because the trustee died. And there you go, you're off to the races. So imagine that. A difference between 2 weeks and 2 years is not unusual when you're talking about real estate and probate and the difference with a trust. The other thing, remember I mentioned that wills are public. Well, trusts are private because it's not filed in court. Nobody knows how much you had, who you left it to, who you left out. Only your named heirs can see it. So reason number 2, trusts avoid probate court proceedings on death. And if you're leaving somebody out, or you leave them less than they think they're entitled to, a will is easy to contest because everybody gets an invitation to the court proceeding and anybody can state their objections. It's kind of laid out on a silver platter for somebody to challenge you because it's already in court. With a trust, you'd have to hire a lawyer, bring the trust to court, and try to prove that you didn't know what you were doing or somebody was influencing you. But a lot of lawyers won't take that case because trusts are much harder to contest because the courts feel, well, if you did a trust, you're a little more sophisticated than the average person, you probably knew what you were doing. And it's not in court, so somebody has to go to bring it into court. But remember, trusts distribute right away. So here's the crux of the difference between challenging a will and challenging a trust. If you're challenging a will, you got all kinds of time because it takes a long time to probate the will. And anytime you issue a challenge, it stops the proceeding until the challenge is decided. So the lawyer challenging a will kind of has leverage over everybody else. Nobody can get anything until they come to the challenging party. So very often they settle because they want to get there, so they give something to the person who's challenging. Well, the trust is quite different because it's not in court and the assets have already been distributed. You're suing the trust, but the trustee already gave out the assets. You have to run after the heirs. People don't want to, chase the horses after the barn door has been left open. It's too late, in other words. So the money's already distributed. It's too late to contest. It's very hard to get the information. You don't know who got what, who didn't get what. It's not a court proceeding. You're going to have a hard time getting a lawyer to do that for you. We also have something called the multiple probate problem. Let's say you have a place here and a place, one of these pastel-colored condos in Florida. You have to probate in every state you own property. So we call this the multiple probate problem. You avoid it by deeding the property from any state into your trust. You avoid the multiple probate. So again, the trusts avoid the court proceeding on death, and they avoid the multiple probate problem. Reason number 3, keeping assets in the blood. So protect the inheritance you leave from your children's divorces, lawsuits, and creditors. Keep your assets in the bloodline for your grandchildren. Wills, of course, don't do this. How many of us on this Zoom know of someone who wife died, husband remarried, wife number two got everything? Well, I can't tell you how many times I've seen that. We want to make sure that your money goes to your children, but if they die, we don't want it to go to their spouses and the spouses' families. We want it to stay in our family. So we want to trust to say that everything I leave goes in trust for my son Johnny, and if he dies, it goes to his children, not his wife and husband number two, or vice versa. So this is the famous Inheritance Protection Trust, the IPT. Uh, we invented it here at Ettinger Law Firm. We've done tens of thousands of them. It's proprietary. It's our trust. I wrote it, and it does exactly what we want it to do. We leave it in a trust for the son or daughter instead of it to them directly. The son or daughter can be the trustee of the trust, and they can spend the whole thing. There's no restrictions on them, so you're not ruling from the grave. However, because it's set up by a third party, it's protected if they get divorced. It's protected if they get sued. And on death, it goes to their children. If they don't have children, it goes back to their brothers and sisters. If they don't have any of those, it goes where you want, nieces and nephews, other family members. But it doesn't go to in-laws and their families. I can't tell you how popular this is. We've done tens of thousands of these trusts. So there's no downside. Son or daughter can spend what they want, no restrictions on them, but they have all these benefits and protections. It's really quite popular. Now, not everybody has beneficiaries who can handle things themselves, so you can protect the beneficiaries from themselves. They could be spendthrift, they could have substance or alcohol abuse problems, they could be special needs, they could be learning disabled, they could be just wonderful people, soft touch, and just very vulnerable to being taken advantage of. They could have a domineering spouse. I can't tell you how often that happens in the office. So if you have children who have a spouse who dominates them, you're not alone. There are many people in that situation. So they have their daughter Mary, who's married to a nasty fellow named Ralph. Um, they they don't want to leave it in a trust for Mary with Mary as trustee because they know Ralph bosses her, and he's going to either take the money or tell her what to do with it. So we can protect Mary from that, or any of your children who have inability to handle assets themselves, by having somebody else as the trustee or the co-trustee. It could be a sibling. There's pros and cons to that. Could be the law firm. Could be another family member. Type of thing we talk about in the consultation. Just want you to know that this type of protection is available. There are options. And I'm very happy to talk to you about that because, as I often said, and I have many chapters in my book under a section called The Social Side of Estate Planning. In many ways, estate planning is more of a social exercise than a legal exercise because you have to unwind the social fabric of the family. Who gets along with who doesn't get along with who, who's best to make medical decisions for you, who's best to handle legal and financial affairs. Should be one of them or more than one of them? Should they act separately or together? And the goal here, unknown even to some lawyers, is to protect the family harmony. Make sure that you have a plan that brings the family together, doesn't tear it apart. I've seen a lot of plans that are perfectly legal that completely destroy a family. So we at Ettinger Law Firm like to say we do the social work first, and we have the legal serve the social, and not the other way around. So, as we know, the Inheritance Protection Trust passes the inheritance on your death by blood. Well, your son or daughter now, on their death by blood to their children, your grandchildren. If they don't have children, as I said, it goes back to brothers and sisters and nieces and nephews, whatever you want. Now, a lot of people tell me, I'm very fond of my, well, let's say my son-in-law. Here's Mary and here's Bobby. So I'm very fond of Bobby. He's been a good husband to my daughter. He's been a good father to my grandchildren. Well, what you can do there is you can say, okay, uh, if my daughter dies before Bobby, give half to the grandchildren at that time, keep the other half in trust for Bobby, give him the income for life, on his death, give the second half to grandchildren. So if he gets married or remarried, wife number two can't get the assets. It's just in an income trust for him. And it's usually managed by one of the Mary's surviving brothers or sisters, or it could be the law firm, but he's not in charge and he can't get the assets. Only the trustee can give them to him. So we say, if you're fond of him and you want to do something for him, you can do that. Um, Generally, income only for half. So what does this do? Basically, this continues your plan for many, many decades after you're gone. It has a very powerful influence on your heirs because it shows them you took the time to deal with things carefully and thoughtfully, and you'll pass that legacy on to them for their planning. So we like trust to keep assets in the blood. That's the third advantage of a trust. The fourth advantage is trust protect your home and life savings from long-term care costs. Wills don't. This is the famous Medicaid Asset Protection Trust, MAPT. Extremely popular. We've done tens of thousands of them. So people place their home and other assets you want to protect into the MAPT to qualify for Medicaid benefits. The way these trusts work, they set up these roadblocks that Medicaid can't break through. So it's called an irrevocable trust. Now, when people hear the word irrevocable, they say, oh, I don't want to do that. I can't undo it. Well, I know it sounds strange, but in New York, you can revoke an irrevocable trust. It's irrevocable because you, or if you're a couple, both of you, cannot revoke the trust. So the law says, so far as you're concerned, that's an irrevocable trust. But New York has another rule on the books that says that if every person named in an irrevocable trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties. What if one of them won't sign? Not a problem. In the trust, you also reserve the right to change who's in charge or change who you leave it to. So Bobby doesn't agree. He says, okay, Bobby, I'm taking you out as a trustee. I'm taking you out as a beneficiary. You're no longer a party. I don't need your signature. And you revoke it on consent of the remaining named parties because he's out. So you can always undo this trust. The point is you have control over the trust. You can change who's in charge, you can change who you leave it to, and you can undo it. That's why I love this trust. It's like having your cake and eat it too. It's there if you need it and want it. It's not there if you don't need it, you don't want it. So the key to the Medicaid trust is you have to name somebody else as the trustee, usually one or more of the adult children. Why do I say that? Because people who don't have children generally not worried about protecting assets in a Medicaid trust. They say, well, look, I'm going to spend it on myself. And after I'm gone, whatever's left will go to the heirs. It's a windfall for them. It's nieces and nephews or more remote relatives. So you're going to prefer yourself and worry about who gets it after you're gone secondary. These are called income-only trusts, and it means what it says. You only get the income. So you have CDs, you take the interest. You have stocks, you take the dividends. So who sets up these trusts and why do they do it? Well, generally, they're people 70 plus is a good rule of thumb. The average age of a nursing home entrant today is about 88 years old. So they set up this trust, but it doesn't affect their lifestyle because they still get their income, which they're generally living on, Social Security, IRA, pensions, interest, dividends. But it doesn't affect their lifestyle. It makes it makes sense for assets you're not going to spend, like your home. Well, protect your home. No downside to putting it in the trust. You put the house in the trust says you have the right to live there, keep all your exemptions, property. You want to sell the house, you have the exclusion from the capital gains tax, 500,000 per couple, 250,000 per single. When you die, the trust gets the stepped up basis. They don't pay any capital gains tax on what they inherit. whether it's real estate or investments. The trust gives you, everything gets stepped up. The basis gets stepped up from what you paid to what it's worth on the date of death. So for example, if you bought a house for 250,000, when you die, it's worth 500,000. The kids get it as if they paid 500,000 and they sell it for 500,000. There's no gain, no capital gains tax. So death wipes out the capital gains tax. The trust preserves that benefit. So your home, a no-brainer, really. Can you sell the house? Sure. The trust sells the house. The money's paid to the trust. Trust can buy a condo or invest the money, give you the income. You could use that to pay a rental. Very flexible. If you have investments you're only taking income from, then there's no problem putting in the trust because the trust will give you the income. And if you have assets you're not just reinvesting, well, certainly that means you're not spending them. You don't need them to live on. If you don't put them in the trust, you're actually safekeeping them for the long-term care industry. Safekeep it for your family instead. So as I said, you have the exclusive right to use and enjoy your own home. You have control of the trust by retaining the right to change the trustees at any time. And if you need long-term care, Medicaid can only get the income from the trust. It protects the nest egg for your children. So there's no look back for home care. There's been a lot of talk about the 2.5 year look back, but it never happened. I don't know if it ever will happen, but uh, if it comes in the future, we want to be prepared. We'll already have our trust in place 2.5 years ahead of time. But today, you have the 5 year look back for facility care and no look back for home care. But it's not an all or nothing rule. If you put the assets into the trust and 4 years later you have to go into a nursing home, you only have to pay for 1 year because you already got 4, which means it pays to get started. Let's go into a little deeper. As I said, the trust can sell the house, buy and sell and trade stock. So you name your son or daughter both as trustee, but you can have them sign what's called a third-party authorization with your Merrill Lynch or Morgan Stanley, and they can sign saying we authorize mom or dad to trade on the account. You can still run the account. If it's online, they just give you the PIN and you log in and with the PIN and you're good to go. So there's a 5 year look back for facility care, only a possibility of a new 2.5 year look back for home care. It's a wait and see on that. But still, they've been talking about that for 2 or 3 years now with no action. So fortunately for us, no look back for home care. So what if you need money from the trust? Remember we said you can only get the income. We can only get the income. You can't take out the principal because if you could get it, Medicaid could get it. But there is a way to get your money out. You have an unlimited gifting power. You can gift tax-free any amount to your children or grandchildren. Well, you may want to just make the gift, so it's nice to know. But if you need 25 or 50,000 for something, you gift it to your son or daughter. They can't give it back to you. That's a no-no because it'll show up in your bank account from the trust. You're not allowed to get it from the trust. But you can give them the principal. They can spend it on you. They can pay a bill. So there is a way to get your money out. Remember, you could revoke the trust really if worse comes to worse, but very rare that people revoke these trusts because they can always gift out what they need to their children and the children pay the bill. As I said earlier, IRAs, 401k, 403b, 457, all retirement plans deferred to age 73 are exempt from Medicaid except for the required minimum distributions. That's income that goes towards the cost of your care. It always gets started. If you don't make the 5 years, as I said earlier, you only have to pay for the time left. I would say when it comes to the Medicaid Asset Protection Trust, there's far more misinformation than information. They're not really well understood. A lot of lawyers, they're not elder law attorneys, they don't use them. Some elder law attorneys don't know all the ins and outs of them. Accountants are mystified by these things. Financial advisors, all kinds of incorrect information. When you understand the trust, it's nothing at all to be afraid of because you understand, well, I can undo it. I can change who's in charge. I can change who to leave it to. I can get my money out. So what's the problem? So a lot of the fear comes out of ignorance. Once you understand the trust, you really are not afraid of it. So what we said in the beginning was that estate planning with trusts create order out of chaos. And that's exactly what they do. Now, let's look at how it does that. It avoids guardianship on disability, so it keeps control in the family. And you also have those asset protection options. Remember the half a loaf. You can, on the nursing home doorstep, you can always save at least half if you haven't planned ahead of time. But it's your people in charge. They're going to come and see us, say, what are my options? And we'll tell them what they are, and then we'll carry out the one they choose. It avoids probate on death. Now the control's in the family, not with the judge. Saves significant time and money in settling the estate, and keeps your affairs private in the bargain. Protects the inheritance. You leave if the children get divorced or sued, and then passes it by blood to your grandchildren instead of the in-laws and their families. Starting to look quite good. And then protects your home and life savings from long-term care costs, makes you eligible for Medicaid for home care and facility care if you need it. Let's talk about our process. There's a copy of my 2025 edition, Ettinger Law Firm's Guide to Protecting Your Future. So the process has kind of begun with this seminar because what we're attempting to do here is build your confidence. And we have a way of doing that. We're going to give you a free initial consultation. And now we'll review your existing plan if you have one, and we'll tell you if it's deficient, where, and why. We'll explain it to you. It's not hard to understand because we do it in plain English. We're going to give you a copy of my book, Ettinger Law Firm's Guide to Protecting Your Future. We'll tell you which chapters apply to you. And sometimes we'll send you to one of our videos. But the whole exercise is a confidence building exercise. Most people who come in to see us are at a low level of confidence. And we feel it's our job to build your confidence up so you know what you're doing, why you're doing it. You have all your questions answered. You feel confident. You made your own choice, and you're able to explain it to friends and relatives what you did and why. So at the first meeting, people want to know what they're in for. In fact, a lot of the questions, how much does it cost? I'll try to give you some idea when we're done here, but we're going to tell you this is how much it's going to cost. And we'll give you the breakdown. And then we're going to ask you to come in for a second free consultation. So you're going to think about what we said at the first meeting. You're going to read those chapters, plain English. That's what your situation involves, these chapters. And at the second meeting, none of you answer your questions, but now we start to draft the estate plan. Who do you want in charge for legal, medical, financial decisions? How do you want the estate distributed all at once over time, in stages, installments? What about special situations? How do we solve those? So this we do all together, and we give you your options. This is what your options are. This is what other people do. This is why they do it. And what do you think suits your taste the best? And then we give you a detailed 3-page written proposal. Same as the fees we mentioned in the first meeting, but here it's formal, so you have it all in writing. And the choice to go ahead is yours. So in our proposal, we're going to tell you not only what we do, but once you become a client, we don't charge for phone calls or emails, and we give you a free review every 3 years. I think that's coming up. But here's something unique to Ettinger Law Firm. I don't know if there's another firm in the United States that does this. We do not use the retainer agreement. Our agreement is a proposal. It says, this is what we're going to do. We sign it, you don't sign it. And it says, we're going to have a third meeting, come in and sign the doc. After everything is signed, you pay the fees at that time. But unless and until you write us a check, you have no obligation to the firm. You're free to walk away anytime. That's the way we want it because we want you in control. So we talk about, putting you in control from the courts, having your people in charge. Control is very important to people, and it's very important to us that you feel in control. And what I realized now a number of years ago was that the retainer agreement takes away control from the client. There's no use me preaching control for these minutes and an hour or so. And the first thing you do when you come into the office is we take back control. How do you lose control with a retainer agreement? Well, you come in, you sign, but and you give the lawyer a check for half, which is standard, but you don't have anything. Actually, what you have is a loss of control. You didn't get anything. You just got a promise. Now you have to hope they deliver. That's not a good situation for you. So what we figured out was, well, um, what's best for you is you don't pay until it's done and you're satisfied. Well, now, if that's what's best for you and we're here to serve you, then we feel it must be the best thing for us. It's worked actually beautifully for many, many years. No agreement, you're in charge, and after it's all done and you're satisfied, you pay at the end. You could pay all at once, you could do it in installments, 3 installments. But we like this. Occasionally we get burned. We do all the work, client doesn't show up ever to sign. But so what? You know, so what? Even if somebody gets a retainer, you can get burned too. It happens. It's a cost doing business. It'll never change for us because this is the best thing for our clients. And the end result, we only have happy clients, which is a nice place to be. So we have that final meeting, review and sign everything, make sure everything gets into the trust, and generally we have very satisfied clients. If you go to our website, you can read our reviews. We have now between 350 and 400, somewhere in there. And, read what people say about us. I mean, we care what we're doing and we do it, we strive for excellence. Do we make mistakes? Yes, we make mistakes. There's not a law firm in the country that doesn't make mistakes, but we try to avoid them. And here's how we deal with mistakes. We stop everything and we fix the mistake as soon as possible. That's how we do it. And we do it on our time, at our expense, and we make it as convenient as possible to the client. Actually, it doesn't happen that often, but it's inevitable when you do legal work. A name could be wrong, a typo here or there. I was listening, I remember a couple of years ago, I heard a lawyer in my office calling a client saying, we made a mistake, you have to come in and re-sign. I said, and I told Laura, I said, actually, that's not how we do it here at Ettinger Law. If we make a mistake, well, we tell the client, be happy to come to your house and bring you the corrected documents. We don't make it inconvenient for the client. We put all the inconvenience on us. So we accept credit cards, but there's a 3% charge, and very few people are paying with credit card these days. Most people pay by check, and they can pay all at once or in 3 installments, as I said before. Now, after the sign the documents, we don't say goodbye. We say hello, welcome to the firm. The standard in New York, in fact, this is what most lawyers do. They say thank you very much, goodbye. Well, I don't even understand it, to be honest. I don't understand how you could treat it as a transaction and not a relationship. I mean, things change, life changes. How can you say goodbye? So we say hello. I trademarked a process back in the beginning of '91 to make sure that the plan works when you need it. So we publish a law letter. I write it once a week. So we keep you up to date with our Ettinger Elder alert because it comes by email. We don't charge for phone calls or emails because we want you to feel free to communicate with us. It's no bother. And every 3 years, we call you in for a free review to see if there's any changes in your family, your birth, your assets, birth mess, all of the above. If you need a change, there's some minor fees for changes, but if there's no changes, it's free. And we do it call you in every 3 years. There we go. No charge for phone calls, emails, or questions. We want you to communicate with us. So the key is by using this program, your plan is never more than 3 years old, and it's designed to work when you need it, not when you signed it. It could be decades earlier. I don't even understand how you could do it any other way. It just doesn't make sense to me. If it has my name on it, an Ettinger plan, I want it to work when you need it. Not, well, it was too old, it didn't work. Well, whose fault was that? So we call you in, we don't wait to hear from you. Okay, so you're entitled to a free consultation. It'll be, we have 8 lawyers. If you are on Long Island, I'm in Staten Island once every couple of weeks. I'm in White Plains once a week. Otherwise, I'm in Rockville Center or Huntington or Lake Success. I move around, but my wife is very experienced. Our lawyers are all very experienced. They all have been with us a number of years. So it could be with any of them. If specifically you want me for any reason and you can get to my office, I'll be happy to see you. How do you make a consultation? You call the 800 number or you visit ettingerplan.com, also trustlaw.com, both the same website. And it's very easy. And these appointments, if you haven't gleaned this already, they're very low key. You'll be very comfortable with the experience. So now let me stop the share. We have our question, a couple of questions that were typed in while we were talking. So let's answer those. Anonymous says, can a required minimum distribution from an IRA be transferred to a third-party trust that is set up for an adult child, disabled child? Yes. You can leave an IRA to a special needs trust, and that's an exception from the Secure Act rule that it has to be distributed in 10 years. If you leave it to a special needs trust, it has the old rule. It can go for the beneficiary's lifetime. So you just name the special needs trust as beneficiary, you get the stretch, the old stretch before the Secure Act. And the taxes are paid on the minimum distributions or more if you take more. Anonymous, can I get a transcript of this meeting? If I have more questions about this webinar, can I email you? Of course. My email is mettinger, so M, my last name Ettinger, M for Michael, mettinger at trustlaw, trustlaw.com. Thank you for saying it's a great webinar. There's a recording of this, so it'll be sent to you, I believe. I'm not the master technician, but I think everybody gets a copy of the recording. Okay, so now let's move on to all those questions that people sent to me. And, questions are interesting. Now, I apologize in advance. I won't be able to answer all the questions because there were too many of them. But I picked the ones that I thought applied to most of us. If your question isn't answered, feel free to, Alex, you raised your hand. Okay. Okay, Alex has a question. Should we be concerned with the massive cuts happening to Medicaid? I don't think so, because New York has a very, very robust and long history with taking care of its senior population, and I believe New York will always do that. So far, we don't see any of the any issues with the Medicaid coming out of the long-term care portion, mostly out of the medical coverage. So it's the other Medicaid, the one for hospitals and nurses for poor people, but not for nursing homes, custodial care. And then Anonymous says, I have a trust drawn up by your law firm when I lived in New York. Now I live in New Jersey. Do you help people in New Jersey? Well, we're not licensed in New Jersey, but if you're in another state and you want a lawyer there to look at it, write this down. Go to the website naela.org, naela.org, and that's the website of the National Academy of Elder Law Attorneys, and you can search by zip code for any elder law attorney that you want. Basically, my advice usually is to look at their websites, find two that you're interested in, go and interview two. You're naturally going to like one better than the other, and that's how you do it. I think 3 is too many. You get confused. You don't remember who said what, and you're taking people's time. It's not really fair. Two should be enough, because you've already done your due diligence. You've looked at their website. You looked at their background. You get so much information on the website. You don't really need more than 2. Rama says, if the house is an irrevocable trust and it's a primary residence, how is the capital gains calculated? Who has to pay taxes? Okay, so the trust, the irrevocable trust, is tax neutral. Tax neutral means the same. By the way, if you raise your hand, you'll have to type the question, okay? So it's tax neutral. It means that you're in the same situation as if you didn't have a trust. It's neutral. So yeah, the $500,000 exclusion if you sell your primary residence. You have the $250,000 exclusion if you're a single person, $500,000 for a couple. On death, you get the stepped-up basis. So there's no capital gains taxes paid by the heirs. Same as if you didn't have a trust. One of the questioners ahead of time asked about the ruling. I think it was Tamara asked about a ruling in 2023 that irrevocable trusts don't get the stepped-up basis. That ruling has been almost the bane of my existence because it doesn't apply to the irrevocable trust that we do. It was a different type of irrevocable trust, but people didn't know the difference, and their accountants didn't know the difference. But no, this is a different type of irrevocable. There's 100 different types, so it was kind of confusing for people. Okay, if you have any other questions, please type them up. The federal tax rate on a trust. Well, these trusts, again, are all pass-through trusts. They get taxed at your individual rate. So the higher rate on trust doesn't apply to the trust I'm talking about. Okay, so the trust is portable. Ellen asked a question here. What if you move to Florida? The trust is portable. If you set it up in New York, you can take it anywhere. Let's see. How do you put co-op shares in a trust? In that case, you have to check with the managing agent and see what the policy is. And they will tell you, first of all, if they allow it. Most co-ops do. And then they'll tell you, they'll either have a package they'll send out to you or your lawyer, or they'll give the name of the law firm that's handling it, and you contact them and then start a discussion. But we handle that for you. A couple of people asked about the special needs trust. You know, the special needs trust for a special needs child, I'm going to cover that in my Zoom side chats. I'm going to talk about the special needs trust. You can register for that on the website. If you like, you can go to the website also. Again, trustlaw.com, ettingerplan.com. And on the website, you can look at my practice areas. I have an article on special needs trusts that'll tell you just about everything you need to know. The New York threshold for estate taxes, if you're under 7 million, roughly, there's no tax. If you're over 7 million, there's a very large tax. So if you're over 7 million, if you're single, we want to start a gifting program. And if you're a couple, you want to set up 2 trusts, then you can double the exemption with 2 trusts from 7 million to 14 million. Won't be a problem for most people. Don asks, we're living together, not married. We were told since we both own assets that we need 2 separate trusts, which would cost more. Well, that's not necessarily correct. It depends on a number of factors, but in most cases, we could do that in 1 trust. And we say, as long as you want your the person you're living with to have the use and enjoyment of the assets after you're gone, you could say, these assets go on my death, these go on the second death, these are in trust for my partner. I think in almost all cases, it can be done in 1 trust. So let's talk about that. Come in and see me if you like. Can an attorney manage the financial aspects for a single individual without family or close friends? Yes, we do that at Ettinger Law Firm. When people don't have somebody else, or they have family members who are dysfunctional, there are a lot of reasons why people will choose the law firm. Sibling rivalry, they don't want to prefer one over the other. So let's see. Okay, Loretta has a very nice. Thank you for your time this evening. I attended a few of these seminars from competing entities. This is the first one. This has gained both my trust and my confidence. Thank you. I look forward to setting up a consultation with the anticipation of establishing a plan of care, and I look forward to meeting you. Very, very nice of you to say that. It's very important, I think, in this area that you proceed at a very calm, comfortable, like relaxed pace. You feel very comfortable. We make sure people are very comfortable and that they feel in charge, that they're making their own decision. So, I appreciate that. I know if you see me or anybody else in the firm, you're going to be comfortable because it's a low-key approach. It's really the right way to do it. Peggy, who I believe I know your sister, Peggy The Inheritance Protection Trust and the Medicaid Protection Trust get the step up in basis. Well, to be clear, the Medicaid trust gets the step up. The revocable trust gets the step up. The Inheritance Protection Trust gets the assets after you're gone. So, yes, when the kids die, their trust will get the step up, but in the meantime, usually we're talking about the step up on the death of the parent. Stanley says, do you need a trust tax return for the trust and yourself? Very good question, Stanley. The revocable trust uses your social security number. There's no tax return. The irrevocable trust, on the other hand, has a different tax ID number. With the irrevocable trust, what we do is, in that case, we file what's called an informational return. And the informational return tells the IRS there's no tax on this trust because all the income is flowing through to Stanley's personal return. So he'll pick up the tax on his personal return. It's a one-page return called an informational return. And we give you a letter for your CPA or tax preparer how to prepare it and to call us if they have any questions. It's a very simple, inexpensive return. Lynn asks, if shares of stock are jointly owned and the primary account holder dies, is there a step up in basis for the stock? There's actually a half a step up on joint assets. There's a half a step up on the first death, the deceased half, the half of the deceased owner. Let's see the next page. Yes, so the one trust can save the New York estate tax and the federal estate tax, but not too many people have a problem with the federal anymore. Now, somebody asked, how do you protect assets over the limits, state and federal? For that, you have to come in and see me because there are so many options here. It depends on the type of assets. You have to play off the value or the disadvantage. You know, if you want to protect assets over the estate tax limit, you have to gift them out, but then you lose the stepped up basis. So it depends on the game is worth the candle, but we do a lot of advanced estate tax planning and keep people under these limits. Somebody said, is a beneficiary entitled to see the terms of the entire trust, or can it be restricted only to what they will receive? Very good question. That's called a redacted document. You can redact the trust so that they only see what they're entitled to. Yes, they only get a redacted copy. So the same person cannot be the grantor and trustee of an irrevocable trust because that will not be accepted by Medicaid. We give a free review every 3 years. There's a fee if you need to change something, but it's relatively modest. Again, more questions about the special needs trust. There's a lot of interest in that. Sign up for my Zoom side chats. It's a 6-part series. You sign up on the website, and I do various estate planning topics, special needs children, planning for singles and couples without children, very common. I should mention, because somebody asked this, if you have a spouse and one of you needs to go into a nursing home, the other one is allowed to keep up to 160,000 on top of the IRA. Remember, the IRA is exempt. You keep 160,000 if you have a spouse. If you don't have a spouse, you can only keep 31,500. When I say keep, I mean if you have more than that, you have to spend it down on your care. The trust is good. So Tom asked, would a trust be equally enforceable in both South Carolina and New York? Yes. You have a home in both states. We deed them both to the trust. Excuse me. There's still a little allergy season there hanging on. I currently have a living trust. What happens when I pass and leave my 2 sons my home? Can they live here? And can you pay taxes I've been paying? How does this work? Well, this is Lydia. Lydia, it depends on the terms of the trust. Does the trust say that the house gets deeded to them? Does the trust say they have the right to live there and continue paying the taxes? Usually the trust says they get the property. And an inheritance can be taken in cash or in kind. So they can decide to keep the house and we deeded half to each of them, or they could say, we want the house sold and give us the money. So if you have a trust and you need to make changes, uh, generally the fee is between 1,500 and 2,000, something like that, to amend the trust. And a lot of people want to know, how much does the trust cost? Well, every estate plan includes a trust, healthcare proxy, living will, that elder law power of attorney, prescription strength. It has the pour over will, which says in case I let something out of my trust, pour it in there after I'm gone. And generally, irrevocable trusts are more expensive because they're more complex. They involve different people as trustees, different tax ID number, more tax planning. But, these days, you're going to spend, somewhere between $6,000 and $10,000 to have a trust done by a competent firm. That's going to be the going rate. What's the difference between 6 and 10? Well, do you want the inheritance trust, or don't you? Do you have one child or two children or three children? Of course, those are more trusts. Revocable, irrevocable. Is it a couple? Obviously, if you're over the 7 million, you're going to go over those fees because you're going to need two trusts, one for the husband, one for the wife, double the exemptions. You might go up to about 15,000 to do everything. There's deed filing fees, etc. So I wouldn't be too concerned about the fees now, because there's a long time between the time you start and the time you have to pay the fees for you to make up your mind and decide whether or not it's worthwhile. But from a business proposition, I think that estate planning saves you money or makes you money. It doesn't cost you money. It's really an investment. And you pay once and then you're done. You can forget about it and you're covered for the rest of your life and beyond. So this Marina writes, myself and my lifetime partner have been together for 40 years, no children, not married, want to leave each other our assets. I'm being told we have to get married to prevent the government from taking our assets. Is there another way out of this? Well, actually, getting married changes the whole picture. And there's no such thing as getting married to prevent the government from taking your assets. If you're young enough, you can set up trusts, and marriage shouldn't be based on reasons like protecting your assets. There are other ways to protect your assets. You get married for the reason that you want to get married. So yes, there is another way out of it. On the other hand, I've had situations where couples have been together 35 years. Wife owns the house. Wife has to go into a nursing home, and husband has no rights. If they were married, it would be his house. They couldn't put him out, but they weren't married. A couple times in my career, I'd say 2 or 3 times, we've had clients get married in the nursing home to protect the house. So that's a possibility. Not a very exciting one, I don't think. But let's talk about it in the office. Find out what your options are and then make the decisions. Again, it's it's a matter of building your confidence, getting the right information, then making the decision. So I hope to see you. If you set up the trust, it's good in any state. You can move to Florida. The trust is portable. So I think that is just about it. I want to look and see. We got a bunch of questions since I started talking. So we got to Stanley about the tax return. Now Cheryl says, can you talk about the new law about transfer on death deed for house? Yes. So last July, they passed a law in New York that allows you to name beneficiaries on the deed. Ettinger Law Firm does that, but there are some drawbacks. You can't leave it to a trust. Might want to keep it in the blood. The other drawback is, if you have 3 children, you leave in the deed, they could be fighting over how much to get. Nobody's in charge. Everybody's equal. So they might not agree on when to sell it, how much to ask for, what broker to use. We have to talk about it. It also doesn't protect the house from long-term care. So it's useful in some circumstances, but it doesn't address all our estate planning issues. Type of thing we have to go over in the consultation. Anonymous says, If siblings co-own a home, can one sibling put their interest into a trust with other sibling? Yes, not a problem. We deed their half into the trust. Anonymous, what does the step up mean? Sure, anonymous. The basis is what's used for calculating the capital gains tax on the sale of the primary residence. So let's say you bought your house for, as I said, 250,000. When you die, it's worth 500,000. The basis gets stepped up from what you paid to what it's worth on the date of death. So the heirs get it as if they paid 500,000. So if they paid 500, they sell it for 500. There's no gain, no capital gains tax. So the basis, which is used for calculating the capital gains tax, gets stepped up from what you paid to what it's worth on the date of death. Tony says, thank you. Very informative, much appreciated. Thank you, Tony. Anonymous, does a change in the trust in future years start the time? No, your grandfather, for Medicaid, it goes on the date you set up the trust and you put the assets in. And that's good forever. They can't, there's a law against retroactivity. They can't go back. I think I'm going to thank you now and invite you to come and see me in the office for a consultation. And thank you very much for joining this evening. Have a nice rest of the evening, and I hope to see you all very soon. Thank you very much, and good night.